Hello everyone, I'm Sidhant. Today the module D of the legal. I will take 5 chapters starting from 40 to 45 to 44 I will cover today. Now starting with that, the meaning and the essential of a contract. So in India, what do you mean by a contract? A contract is just an agreement between the two parties, creating a legal obligations for both of them to perform a specific task. Since human tendency is to not to believe others, so in order to create a legal angle, any government or any previously or the people have introduced this contract so that they are legally bound, because they are putting their sign on it, and they are liable to perform the duties or the task they have been under this contract. So the concept of contract comes from that. Now in order for the contract to be enforceable, each party must exchange something of value called consideration. Okay, for any contract to be enforced, there is something legally backing of the tasks or anything. For example, let's say you have did a contract with somebody to do some task for you, but he is not able to complete that. Then in the contract itself you will write in the language like, if the person is unable to fulfill the contract, then he would be liable to pay the compensation amount as per fixed by you. So this is called a consideration. So when anything like the task here is backed by something like the money or the monetary value, then it is called a consideration. It's a concept of the contract. Now the contract can be oral or written, and contract is used in a sale of land, goods, or provisions of services. As I told that for any completion of the task or for the task performance, a contract is done, and also for the sale of land and the goods, the contract usually takes place. Now element of the contract, these are the main elements of the contract, like the mutual assent. The contract could only be construed when both the parties are mutually agreed on that, then only the contract could possible. So this is an element of the contract. And other is offer and acceptance, that someone is offering services and someone is accepting that services in lieu of something. Consideration, I already told you, something in value to make agreement binding. What I wrote here, this is the same thing. Now the capacity to do work and the capacity to pay compensation is also taken as an element to do the contract. And the legal purpose, there should be a legal purpose, like selling of the land or the services giving is for the legal consideration, so that they are legally bind to do the services. That's why the contract usually takes place, or it's an element of the contract. Now for the contract unforeseeable, it's a dues agreement against their will. Okay, any contract done by the person can be unforeseeable and cannot be put it into the court. Unforeseeable means that it cannot be practiced, it cannot be go into the court, it cannot be valid into the court. That's the meaning of unforeseeable, that it could not be enforced because of some lacking of the process or some lacking of the things. This unforeseeable takes place, and what all those things which led to the contract to unforeseeable in the court or any place is as follows. Now the duress means agreement against their will and violation of the public policy. Public policy means that you are contracting with some other person in order to kill some other person, that is against the public policy. And non-disclosure, that you are doing a contract and you are not disclosing the things, then this is called this is unforeseeable, and this led to the unforeseeable. The contract becomes the unforeseeable when this happens. And impossibility, like I will displace the Himalaya mountain from India. If this contract takes place, then this is unforeseeable because it could not be possible at all. And illegal purposes like criminal, for drugs, peddling, etc., these are not allowed. The contracts are already void in that case. Lack of capacity is also the contract unforeseeable. It could not be enforced if it's a lack of capacity. Now as I said, the contract can be oral or written, and some shall be written only, and that which should be in written is the statutes of fraud. And for example, the surety and the guarantee contracts are the example of the statutes of fraud, because these could only be written only. It should not be oral, because even when we join the banking industries, we used to sign the bond, and that is not oral, that is written only. That's why, and that is called the statutes of fraud. And there are contracts where one party agrees to be responsible for another party's debts, is called the you can say that surety. These are the meaning of the sureties contract. So here we saw two type of contract, that is that the contract which should be written only is called the statutes of fraud, and surety and the guarantee contract is the contract where one party agrees to be responsible for another party, is called the sureties or the guarantees contract, because one party is giving guarantee for the other, because because at this time he is not able to give the full surety of the contract. That's why the other person, which is called a surety, which gives the surety that they will do if this person in future unable to do. For example, in the student loans, education loan, the parent signs also put it into place, because if the student is unable to repay the amount because of any reasons, then the parents are liable in that case. Now, contract for consideration to marry, or also these are the contract which should be written. These are the example of the statutes of fraud, and these contracts should be written only. It should not be oral. And the contract for the consideration to marry is also the example of statutes of fraud, or you can say that it should be written contract only. And the contract that cannot be fulfilled within 1 year of the start of the contract, that is also called that is also the example of statutes of fraud, and it should be written only. Now, the breach of contract, the compensatory damages, liquidation damages, and the punitive damages, etc., should be paid if the contract is breached, and it could be paid according to the judgment given by the courts and the higher authorities. Agreement is one of the element of the contract. So what is agreement? It's a part of contract. Contract is a bigger thing which is defined by the Indian Contract Act, and agreement is one of the part of the contract. Okay, that's it for this chapter, that is meaning and the essential, the chapter number 40. The other 4 chapters are very small. It will be done in one of the videos, in only one videos. Okay, thank you.